So now we're going to go on to the sessions, and the session number 1 is about trends and IP issues in the metaverse. So from Chosun University, we have Professor Ji Young Han, who's going to talk about the Korean trends and IP issues in the metaverse. Once again, please refrain from applauding as the speakers come onto the stage. Now invite the professor onto the stage. Good morning, everyone. It's good to see you all. So I'm going to be talking about the trends and IP issues in the metaverse in the case of Korea. My name is Ji Young Han. I'm a professor at Chosun University. Recently, this issue of metaverse has been used quite broadly in the academia, industry, and also by the government, and it has become a really hot topic. And also in the academia, we have had a lot of symposiums, and the government also has invested a lot into coming up with different policies related to the metaverse. So as Professor Sang-Kyun Kim had said, the metaverse is giving a rise to a lot of legal issues, and a majority of them are actually related to intellectual property. And so I think in that regard, today's global forum is really meaningful because we will be dealing with particularly those issues. So this is the content of my presentation. So you all know what Metaverse is about. So it brings together meta and universe. So on one hand, you have the augmented reality and AR, then you also have live logging, you also have mirror worlds and virtual worlds. So these are the 4 different types of metaverse. So I'm sure all of you know all of this. And so these are the 4 different types of the metaverse. In the case of augmented reality, it's a fantasy on top of the real world. So for example, Pokemon Go game was really popular, so that would be an example. Live logging is actually sharing the data from your everyday life through the digital space. So vlogs and social media would be examples. And then the mirror world would be exemplified by Google Map and delivery services. And the virtual world is actually a world where you can interact with other people and get involved in social activities in the virtual world. So Roblox would be a major example. And so in Korea, you see a particular trend related to metaverse. So if you look at the statistics, you can see that the metaverse market is increasing very rapidly. By 2022, the market size is expected to be 61.8 billion US dollars, but that is expected to grow to $426.9 billion by 2027. And so the growth rate is something like 47.2% per year. And so with the new technologies being developed under the pretext of the 4th industrial revolution, the metaverse market is rapidly growing according to these statistics. And if you look at Korea, well, Zepeto, developed by Naver, has become really popular. As of March of 2022, the number of subscribers, or the members, is 300 million. And in Zepeto, we had the autograph event of the girl group Blackpink in 2020, and Gucci also collaborated with Zepeto. But in the past, in Korea, there had already been some infrastructure. So, for example, in 1998, in January, that was already 20 years ago, you had the cyber singer Adam. And the album sales recorded 200,000. And then there were virtual influencers. Actually, Adam, the cyber singer, was a virtual influencer. And all Koreans know Cyworld. It was created in 2000. And you could also create avatars, and you can have your mini website. And it's sort of like a social media that you can communicate with other people. So it was a website where you can have a multi-persona. So I believe that Cyworld was actually the first of its kind. And something like Cyworld has reappeared nowadays. But anyway, going back in history, in Korea, you could already see some signs that are similar to Metaverse 10, 20 years ago. Now, going on to the government side, the government has come up with a digital strategy on Metaverse. So one strategy is to foster talent regarding Metaverse. The second is to vitalize the ecosystem or the platforms. And then thirdly, to promote more enterprises in the Metaverse. And so these are some of the components of the digital strategy on Metaverse announced by the Korean government. Now let's go on to the main topic of my presentation, which are issues on IP in the Metaverse. So there are a variety of different issues related to intellectual property, but I think there are three main areas. So the first case is when creative works are being used in the Metaverse, but it was created in the Metaverse. Issues related to that. The second area would be about IP issues related to creative works that are being used in the real world, but which were created in the metaverse. And the third area would be IP issues related to creative works that are used in the metaverse, but which were created in the real world. So these three areas were the main categories. So now let me go on to the different types of intellectual property. First is patent-related issues. And I think actually majority of the IP issues that are raised in the metaverse are design, copyright, and trademark, and also about unfair competition. So we don't yet see a lot of patent-related issues in the metaverse as of yet. So, that's because you don't really see an avatar being able to make and complete an invention and register a patent. So for now, I think it's not going to be possible. And in a platform, a avatar will not be able to complete and then register a patent. That's because the technology behind Metaverse are not really being operated within the Metaverse, but by the real world. So it's actually run by computer programs. So you have patents registered regarding the computer programs or the VM. And so, but regarding the patents, the majority of the patents related to Metaverse are owned by Microsoft, Samsung, Magic Leap, etc. So you have a lot of American companies. So in this, Samsung is a Korean company, and it is focusing a lot on Metaverse and is really putting in a lot of effort into patenting some of its technology. But then you have the patented method invention, but that can be used without authorization in the metaverse. Could that be considered as a breach of Patent Act? Well, I think there is a likelihood that this kind of unauthorized use of the patented method invention could actually violate the patent right. And so, for example, in the metaverse, a virtual machine can perform certain steps just like other machines, and anyone can prove the infringement by showing that the VM performs each step in the relevant claim of the specification. And under the Korean Patent Act, the concept of practice or the enforcement of the invention is regulated, but that is in relation to only the real world and not the virtual world. And so there's the question of whether the concept of enforcement or practice could be applied also to the virtual world, or whether we would need to revise the legislation to accommodate the virtual world. Then there are many trademark issues in the metaverse. For example, you have the McDonald's and you have Nike, and these companies are actually registering their trademark in the digital world. And also other fashion brands and logos and designs are using avatar to distribute their products in the metaverse. But then there are also a lot of counterfeit goods that are being circulated in the metaverse, leading to the rise of trademark violations. So we see a lot of violation of trademark. So how do we classify the trademarks in the metaverse? So first of all, it could be an avatar who had created a trademark. And in order to register the trademark, he or she has to designate it at least in one of the categories according to the classification of the goods. But it's once again in the virtual world, it's a virtual good. So how are we going to categorize this virtual good? So there was a discussion within Kipo and also around the world. And so the discussion has concluded that the goods in the metaverse, because it's virtual, can be considered as a downloadable image file. And so Kipo actually this year came up and published the examination guideline on virtual goods. And so it became to be implemented since the 14th of July of this year. So for now, if you look at the number of applications for the virtual trade marks, it used to be 6, but that increased to 17. But as of May, it increased to more than 700. So it's compared to last year, it's a huge increase, an exponential amount of increase in the number of trademarks, the virtual trademarks. Anyway, thanks to the examination guideline of virtual goods, you can see that in Korea, a lot of virtual trademarks are being registered. And based on the examination guideline, you also have the code of similar classes to be able to categorize the different goods. So there are many issues related to trademarks. So let me just look at two main issues. One is the unauthorized use of counterfeit products. And so basically, it's a dilution of the trademark. And so a trademark dilution occurs when a well-known trademark in Korea or overseas are used for unjust purposes in the metaverse. And so that would lead to a dilution of the trademark. And so if the purpose of the use of the trademark is the same in the metaverse as in the real world, then that would also constitute an indirect infringement of the trademark. And the second category of the issues relates to the use of goods or services in the metaverse. And so sometimes the real goods are combined with virtual trademark in the metaverse, or real trademarks are combined with virtual goods. And so these acts lead to an unexpected use under the current act. And then it's also sometimes the case where the digital goods are transmitted online or are provided as a streaming. And so that can also lead to a trademark violation. And there's a debate on whether it's a violation of the Trademark Act. And so then we in Korea, either we need to think about whether we need a new interpretation of the law or a new enforcement of the law. So we need a lot more judicial precedents regarding the trademark issue. And so we need to discuss the concept of the infringement of trademark rights, because we would have to see whether it can be viewed as an online transmission of a digital good or not. And so we would have to see whether the unlawful use of the trademark in the virtual world should be included in the scope of protection of trademark rights. The third set of issues related to IP is the design issues. So you would have to be able to prove the materialness in order to be able to be guaranteed as an article to be designed to be guaranteed the design right. But last year, there was an amendment to the Design Protection Act to protect the design of a screen design. as a part of an article. So basically, if the metaverse is created, then it can be protected. And the designs in the metaverse is not based on an article. And so that means then there is an issue of how we're going to protect this kind of design in the metaverse. So the KIPO has revised the act and so has come up with a concept of the screen design. And when we say screen, it basically means a signs or expressions that are articulated through a device. So it's a screen design is used usually in the operation of a device or displayed as a result of the device performing its function. But the screen design, which is a part of an article, cannot be specified within the article, and so it's not really easy to get a design registration. And so in the metaverse going forward, if there are contents and that are transmitted and that are used that are not based on the article, then there has to be some legal provisions to be able to cover or accommodate this kind of change. So, and we could also think about deleting this kind of expression or provision in the law, or maybe come up with an alternative kind of provision or legislation to be able to cover this kind of design rights in the metaverse that are not based on an article. But another alternative could be to protect the design as a screen design. But this is also not limited to the operation of a device or displayed as a result of a device. So it could be one methodology to protect the design. The fourth IP that we need to deal with in the metaverse is the copyright issues. So a lot of the K-pop has been used without licensing in the metaverse, and also a lot of K-pop is being used without consent also in Roblox, and so there is a litigation taking place right now in Korea. And so the copyright issues in the metaverse has risen as a very important topic. But then how are we going to protect the works that are created in the metaverse? Is it copyrightable or not? So in the metaverse, you have many different avatars, and they are engaging in creative activities using the tools provided by the metaverse platform. So are they copyrightable? So a provision does not exist right now in the copyright law, but the works created in the virtual space can be considered to be computer programs or visual artworks or cinematographic works. And in the case of Zepeto, they have a policy in place, and so if the users or the avatars create a work and it's being used in the metaverse, it'll be regulated by that Zepeto policy. And so the ownership of the works created in the virtual space is attributed usually to the creator, because you have the creator principle in the copyright law. And so the person who actually created the works would be considered the creator and the copyright holder. But then you also have the metaverse platforms, and they also have a platform. They also have a policy in place that allows for the works to be used without the permission of the creator, according to the clauses of the contract between the creator and the platform operator. And so you have these contracts in place between the creators and the platform operators. And so Roblox and the Zepeto, they also have these kind of policies in place that allows for the comprehensive licenses. So creators usually register their work with the KCC. And if a third party in the metaverse uses this work or creates a derivative work in the metaverse, then the third party would be violating the reproduction rights in the copyright law. Or if he or she modifies the work, will then be violating the right to integrity or the right to create derivative works according to the copyright law. And so another big issue related to copyright in the metaverse is the avatars screening a music video or avatars doing a performance. So if that is the case, would it be considered to be webcasting or broadcasting, performance or transmission? So there is a huge debate of how we are going to view a performance by an avatar. So usually an avatar performs through a motion capture, and it can dance and it can sing. And it looks as though it's a performance by the avatar, but in fact, it can violate copyright. And so artists' music and dance are protected by the copyright law in the real world. So if there is a dispute related to the violation of copyright in the metaverse, it's going to lead to quite a big debate, especially regarding the economic interests of the different stakeholders, and it can really change the paradigm. There is also the issue of unfair competition. So unfair competition is also very important because it is quite related to the issue of trademark. Last year, there was a revision to the Unfair Competition Prevention Act in Korea, and so the unauthorized use of the real-world trademarks in the metaverse would also be covered, but there are various criteria. So first of all, if there is a unauthorized use of the real-world trademarks, for example, if you open a store similar to a Nike store in the metaverse and you sell virtual shoes or clothing, that would be considered as a violation of trade work. Or if you perform a performance that is quite similar to a famous singer or a famous musical on the metaverse, that could also be a violation. But then the second category of the unfair competition issue would be the dilution of well-known marks. So also according to the Unfair Competition Prevention Act, you can also say that the act of decorating and selling chicken restaurants, for example, using the Chanel mark would constitute a dilution of a trademark. Or if you, for example, use the trademark Nongshim, which is a very famous ramyeon brand, in the metaverse, or for example, if you change the logo Enjoy Coca-Cola into Enjoy Cocaine in the virtual world, that would also be considered as violation of the Unfair Competition Prevention Act. Also, the act of selling bags and shoes that imitate brands less than 3 years after their launch, or the act of crawling a competitor's information would also be a violation. Also, the act of unauthorized renting or the advertising of performance videos in metaverse, or using deep fake technology to create avatars out of idol groups could also constitute a violation of the antitrust law. There are some other examples as well. So, for example, if you reproduce a famous building within a metaverse, that could also be a violation of the Unfair Competition Prevention Act as well as the Copyright Act. So anyway, there are many, many more examples of how there are violations of the Unfair Competition Prevention Act in the metaverse. And so going forward, we need a lot of discussion on how to resolve these kind of disputes in the metaverse. Then I'd like to go on to the issue of the jurisdiction. So as you know, when it comes to the IP, there is the principle of territorialism, but the metaverse exists in a virtual space and there are no national borders. So how are you going to apply the issue of jurisdiction when there is a dispute in the metaverse? So when IP has been infringed in the metaverse platform, the problem is that this kind of infringement occurs in an online environment, and so it's global and it's very transborder. And so in which jurisdiction are we going to litigate in? Professor Kim had talked about this issue of jurisdiction, and it's going to be a big issue related to metaverse because there are various types of violations and infringement of rights in the metaverse. So are we going to use existing legal provisions, or do we need to come up with new legal provisions, or is there going to be an alternative method of resolving this territorial and jurisdiction issues? So in Korean's case, there was a revision of the Act on Private International Law. So it was not really taking metaverse into account per se, but the recent revision on the Act on Private International Law can actually include metaverse. So, for example, you have Article 2 and Article 8 regarding the international jurisdiction and the jurisdiction of agreements. But anyway, I think Professor Kyu-ho Lee is going to explain this further in his presentation later on. So this part is about the agreement. So if there's going to be an agreement, then it should not be a part of the inclusive jurisdiction of a foreign court. And also the Korean court should have jurisdiction over the case, and the case has to have reasonable relevance to the Court of Korea, and the exclusive jurisdiction agreement should not be unreasonable, unfair, or contrary to public order and morals. So these are some of the criteria for the validity of exclusive international jurisdiction agreement on Korean cases. So how are we going to protect IP in the metaverse, and how are we going to promote use in the metaverse? So we need a balance between the two. But then if there is unauthorized use, what law is going to apply and what jurisdiction is going to apply are some of the most disputed issues and challenges posed by intellectual property in the metaverse. Now, moving on to the conclusion. So right now in the Korean law, there is nothing about the metaverse as yet. But there are many attempts to resolve various disputes that are coming up in the metaverse related to intellectual property. So there are many attempts. And so the metaverse is like a virtual space where avatars communicate and live as Second Life. And this has come about as a result of the digital technology. And so there are many users who are creating their own avatars, but at the same time violating protected works. And there could be a lot of different issues like patent violation and trademark and copyright violations, and also antitrust law violations as well. And so it's really difficult to find the solution to these disputes in the existing legal system. And so the industry, the academia, and the government have to come together to come up with ways to solve the IP issues. So we need to discuss how we're going to revise the existing legislation, or whether we're going to come up with a brand new legislation. We also have to have a multi-stakeholder discussion about the different government policies that are needed. And so we have to think about a paradigm shift in regard to the legal system. But of course, this issue is not limited just to Korea. This is an issue on a global level. So perhaps the WIPO can take the initiative of promoting this kind of discussion, particularly because it involves cross-border disputes, and we have to think about the jurisdiction. We also have to think about global ways to resolve disputes. So with that, I'd like to end my presentation. Thank you very much.
한지영 교수님의
Thank you very much, Professor Jiyoung-han. So we heard about the trends and IP issues in the metaverse in Korea. The next presentation will be given by legal counselor Thomas Dillon from WIPO. He will be speaking about overseas trends and IP issues in metaverse. Please make use of the interpretation receivers. So we will be hearing about overseas trends and IP issues in the metaverse from legal counselor Thomas Dillon from WIPO. Because he wasn't able to join us in person today, he will be meeting us online.
My name is Thomas Dillon. I'm a legal counsellor in the Building Respect for IP division of the World Intellectual Property Organization, and I've been asked to speak to you for 20 minutes on the subject trends and IP issues in the metaverse overseas. I'm going to cover three essential areas. First of all, I'm going to offer some comments on the nature of the metaverse. Secondly, I'll look at some substantive legal issues relating to trademarks and copyright. And finally, I will talk about the most important issue to which the metaverse gives rise, which is that of enforcement. Now, the metaverse is a very popular word or concept at the moment. Even the World Intellectual Property Organization has been active in the metaverse, it is said. Last year, we organized a training event that took place using the GatherTown platform, which is said to be a metaverse platform where people were able to speak to one another, extraordinarily enough. Is this the metaverse? Let's ask the metaverse's most prominent advocate, Mark Zuckerberg of Facebook. Mark says that the metaverse is a persistent synchronous environment where we can be together, which he thinks is probably going to resemble some kind of hybrid between the social platforms that we see today, but an environment where you're embodied in it. So the idea is that people represented by avatars are able to move and operate in a digital environment which is wholly self-contained and in which they can do all sorts of things. The metaverse, as so described, seems to be a combination of three different businesses or types of business. First of all, you have the online games business. Secondly, the virtual reality business, which is a technical contribution, of course, to permit a 3D experience. And finally, you have social media, the social element. Those three industries, if I can put it that way, overlap in the place where the metaverse is to be found. The first thing to be said about the metaverse is that it is not new. Defined in the way that we've heard, Second Life, which was launched in 2003, is a metaverse. In Second Life, people represented by avatars operate in a virtual environment. They can move around, they can buy and sell things, they can dance, they can play. It's a metaverse. Roblox, very successful metaverse, explicitly described as a metaverse, was founded in 2006, and it's the same story. People represented by avatars can act under their own volition in a virtual environment. Intellectual property is not a stranger to the metaverse. The first known trademark registration for a business existing in such an environment is the two trademarks granted by the United States Patent and Trademark Office to Alyssa LaRoche for her business, Amy Weber Studio, which was a business operating in Second Life, purely metaverse business. And she applied for and obtained trademarks in the ordinary way for that business. The second thing to say about the metaverse is that it is not the same issue as non-fungible tokens or NFTs. There seems to be an assumption that there's a necessary connection between the metaverse and NFTs, but there is not. NFTs are, as it were, a digital receipt, which is connected with some kind of asset, which is hosted outside, usually outside the blockchain. Now, while NFTs may have some role in some metaverses and may permit the interoperability or the transportability of digital assets from one metaverse to another, they're not intrinsically connected with the concept of the metaverse. And indeed, in the online games community, the introduction of NFTs to that sort of online environment is very controversial, as these headlines indicate. You don't need an NFT to track ownership of a digital asset in a digital environment. If we look closer at the metaverse as described, it seems to me that really it's overwhelmingly a variation on the video games industry. The metaverse is essentially a looser version of a massively multiplayer online role-playing game. This is a very big industry, of course, the games industry, and it's very largely online. And in online gaming of that sort, you have people operating as avatars, moving freely in a virtual landscape and acting under their own volition to do various different things. And virtual objects are created in these environments, and they may be bought and sold. It seems pretty similar to the metaverse, except that in the online gaming environment, the objectives of the avatars are to a great extent directed by the people who've constructed the environment, whereas in the metaverse, the idea is that there's a greater degree of freedom for the avatars to do things. But fundamentally, from an IP law perspective, there doesn't seem to be a lot of difference between the online gaming environment and the metaverse environment. Virtual reality, of course, is just a technical contribution, which is required to give a 3D experience. Though whether 3D is absolutely essential to the metaverse is another matter. And then you have, of course, social media. I believe that there's a social element already in some forms of game playing, but certainly once the metaverse gets going with its backers coming from the social media world, social media, of course, will be more important. But it doesn't greatly influence the nature of the phenomenon, it seems to me. However, the picture is quite different when we think about it from an infringement perspective. And it's important to understand that the games industry is not in the same position as it was 20 years ago when it comes to piracy. Nowadays, with the important role of online environments in the gaming industry, the ability of gaming companies to control the environment is much greater than it was in the days when games were bought and sold on discs or on cartridges. So in the gaming environment, we will continue to see, I'm sure, in the metaverse environment, we can continue to see the kinds of piracy problems that you see in the games environment, but I don't see the metaverse introducing anything new. And what I think will characterize infringement on the metaverse is actually the social media. Social media is already a massive vector of copyright and trademark infringement. You have private groups sharing live video streams or recorded media. You have people selling large quantities of counterfeit goods. And those aspects of the dark side, as it were, of social media will no doubt continue in the metaverse and perhaps even be accentuated. You will also have in both environments the problem of user-generated content, which infringes third-party rights. And this is the kind of thing which you will see, I'm sure, as you do in the online gaming environment. This is an example. A couple of years ago, someone used perfectly legitimate modding tools contained in the Dreams game environment to create a character who was a copy of Mario, the well-known well-known games figure. Now, Mario as a character is owned by Nintendo, but the game Dreams was a Sony interactive product. Nintendo saw this digital construction as being an infringement of its copyright in the Mario figure, complained to PlayStation, and PlayStation simply prevented the person who created the fake Mario from continuing to use it. And that illustrates a very important aspect of these enveloping environments, which is that they are permissioned environments. They are environments in which the person who controls the environment has complete power over the avatars, indeed even the ability to extinguish an avatar. Capital punishment for infringement would be a possibility in the metaverse. But this again is nothing new. Now, turning to those liability issues that I was mentioning at the beginning, although you will gather that I think that the importance of the metaverse as such for intellectual property is rather limited, it is the case that the metaverse brings focus onto certain problems relating to registration of registered rights. So, for example, if I register a mark for handbags, does that cover the sale of virtual handbags, a digital handbag, for example, in a metaverse environment? Well, this is really a question of how you draft the rules in the first instance, and registering authorities, for example, the European Union's IP Office, have already issued guidance to indicate how they will handle applications for registration or the classification of marks in future. The EU IPO, for example, says very sensibly that while you can apply for a mark in class 9 for virtual goods, you must specify what sort of goods they are. And so far as the niche classification is concerned, which is one of WIPO's responsibilities, the niche classification already had ample provision for descriptions relating to downloadable media, but from the 1st of January of next year, there will be an additional category for downloadable digital files authenticated by non-fungible tokens, for what that's worth. And of course, in Korea, you have also issued guidelines on the same subject, which you know more about than I do. Now, leaving aside registration as such, both in relation to opposition to registration and infringement, the question of likelihood of confusion arises. Would consumers probably confuse the source of a product or service as a result of the use of a particular mark, as against the products or services of a registered mark, a prior registered mark? In fact, this is not a problem. It's a seeming problem, but it really isn't one, because the issue, the function of the trademark is to indicate the trade source of a product or a service. And the trade source is always a business, whether it's a service providing business or business that provides goods. So, for example, in the case of Hermes against Rothschild, which is currently proceeding in the Southern District of New York, it was a case where someone was selling digital images of handbags which looked like the handbags sold by Hermes under the mark Birkin. And Hermes sued the defendant for trademark infringement and other similar causes of action. And the judge, on a preliminary motion at least, had no difficulty in saying that the sale of digital handbags, as it were, in picture form, was within the protection, as it were, of a mark for handbags. And this is the mark, in fact, in the United States, which Hermes was relying on, the Birkin mark, a mark for leather goods, including bags. It is interesting to note although they haven't had any trouble as a result of not having a mark for digital goods, that in August, at the end of August of this year, they applied for another mark with the same word, Birkin, for downloadable objects. So perhaps that's an attempt to cover themselves in case it turns out there is a problem. But so far as one can see, there is no problem. Now, online service providers benefit in most countries from protections, which are referred to as safe harbors. In the European Union, it's the Electronic Commerce Directive, which is soon to be replaced by the Digital Services Act. In the United States, it's Section 230 of the Communications Decency Act. And the question will be, to what extent the operator of a metaverse is entitled to rely on those protections. Typically, the protection is conditioned on notice, so that if you become aware that you are hosting an infringing item, then you must act expeditiously to remove it. But unless you're given notice, you don't have any liability. In relation to Section 230 in America, the question more precisely is whether the defendant is acting as a publisher, because essentially its main purpose is to protect speech. And this is being thrashed out in the American courts at the moment. There's a case against Roblox relating to the cancellation of digital goods. Roblox, in its terms and conditions, allowed people to create and sell digital goods, but then they reserved the right to cancel or delete those goods if they wish to. And they have been sued by someone who complains that this is an unfair commercial practice. It's not an intellectual property case. And in that case, the court said that such activity was simply outside the protection of Section 230 because there was no question of Roblox acting as a publisher. On the other hand, there is another case, Coffee and Google, which is a case about the alleged liability of Google for making available games in its app store, which included loot boxes. Loot boxes are kind of a digital purchase that you buy in a games environment that contains unspecified benefits, such as a skin for a weapon or something like that. Now, the argument was that these were illegal under Californian gambling law. Again, not an IP case. In that case, though, the court said, well, Google is making these games available. It's obviously not responsible for the content of the games, and so it is acting as a publisher. And so in that case, Section 230 does protect it. And it seems to me that that's probably going to be the way in which the courts deal with the responsibility of metaverse providers for the activities of people on the metaverse. Now, in relation to copyright, there doesn't seem to me any problem about according copyright protection to creative works which are created in the metaverse. If you create a digital object that's of, for example, of any kind of artistic character, then it would seem to be an artistic work. It might also be protected as software. But there is an interesting question, perhaps not of very great practical importance, as to the location of publication of that work. You'll recall that under the Berne Convention, a foreign author is entitled to protection if a work was made by a national, or if he is a national of a member of the Berne Convention, or his work was first published in a country which is a member of the Berne Convention. Now, normally, the question of the place of publication won't be reached because the author will almost inevitably be a national of a Berne Convention country. But it's just possible that someone from a non-Berne country would publish a work in a metaverse, and the question would then be, was it being published in a Berne Convention country? Since that is only of practical importance as to the term of the copyright, whether it's long or very long, probably will never be decided. But that's an interesting academic question that arises. So far as infringement is concerned, it's my contention there is nothing in the metaverse which is not already an infringement issue in the online gaming environment. And in that connection, I would recommend to you a new report that has been made available by WIPO this year on copyright infringement in the video games industry. I believe that if you that really tells you all you need to know about copyright infringement in the metaverse. There are clearly issues about what is or is not infringement, how things are protected, but they are the same issues in the video games industry, and that's something people have been thinking about for quite a long time. You also have the question of the safe harbors. In this case, again, it's the European Union's 2000 directive, Section 512 of the Copyright Act in the United States, Article 102 of the Korean Copyright Act. And again, the same principles apply. On the whole, if you don't know about the infringement and you're not responsible for the infringement, you only become liable as a metaverse provider if you have notice and fail to act to stop the infringement. One thing that's optimistic about the metaverse is that right holders increasingly are demanding that online service providers know their digital customers. This is a concept which comes from the anti-money laundering world. They say you should know whom you're dealing with so that if there's a complaint, it's possible to locate and identify a defendant. Now, in the metaverse, as a completely permissioned environment, this is surely much easier than it would be in the real world. And finally, I would point out that anyone who thinks that national courts will lose their power over the activities of people in the metaverse, or indeed the activities of metaverse providers, is wrong, because courts will continue to exercise jurisdiction to protect their consumers in accordance with their general law. Finally, let me turn to the question of jurisdiction. And this, although again, there's nothing new in this, this is something which will be given greater emphasis by the metaverse. And it's about the localization of the infringement. Now, if you wish to bring proceedings against the defendant for IP infringement, you can sue him where he resides, but that may not be convenient or possible. So you may wish to sue him where the infringement took place. And in most countries, as I understand it, if the harmful event took place in your jurisdiction, then you can bring proceedings in that jurisdiction. That's the rule in the European Union. In the United States, it's very similar. So the question then is, where does an infringement take place when it takes place in the metaverse? Now, this issue again has been debated for years in relation to the internet, more generally. In the European Union, the current solution is to ask whether the infringement targets a particular jurisdiction. For example, suppose that it's a stream of a live sports event. Is the sports event of interest to that particular market? Is it the national team playing, for example? Is the language of the market being used? Is payment required? And if so, is the currency of that market accepted, and so forth? So if those tests indicate that there's a sense in which the infringement is targeted towards the country in question, then proceedings can be brought in that country because the infringement is taking place at least there, if nowhere else. In the United States, a somewhat simpler test seems to apply, at least when the performance right is being relied upon. The mere appearance of an infringing image on a screen within the United States gives rise to an infringement in the United States. So there's a tortious act at home, as it were. Now, the problem with the metaverse is that it will become increasingly difficult to determine whether there has been any targeting of an infringement. And it seems to me that the European test will come under increasing pressure because it will simply not provide a remedy in blatant cases of infringement. But that remains to be seen. Perhaps the European legislator will have to step in eventually. So those were my brief views. I should say that these are my views. They are not the views of the World Intellectual Property Organization or its member states. but I'll be very happy to participate in the panel shortly. Thank you very much.
네, 토마스
Thank you very much, Mr. Dillon, for your presentation. Mr. Thomas Dillon is a legal counsel at the WIPO. That brings us to the end of the session number 1. We're going to now have lunchtime and then move on to session number 2. So please stay where you are, and the lunch boxes will be delivered to your seat. Please enjoy your lunch, and we'll see you at 1:30 for session number 2 in the afternoon. Thank you very much, everyone.